This is James Angelo, broker of Florida Home Realty and Mortgage. This video is on protecting your practice. This is going to be a series that I'm going to be doing as things hit my desk or at the firm. Now, this particular video is on the wire transfer fraud disclosure as well as the buyer and seller disclosure. I do want to make a note that these two disclosures will be effective as of June 1st, 2017. So if you have any prior versions, I really need you to take those versions. I need you to get rid of them, delete them off your system. These are currently uploaded on Back Agent, so please go to Back Agent, get the new disclosures. That's imperative. The wire fraud disclosure, just for reference, is a one-page disclosure. Now, I'm not going to read all of it, but I will read one small part, and it's basically in the last section of this disclosure. It basically states that I hereby agree to indemnify and hold harmless Florida Homes Realty and Mortgage, LLC, Florida Homes Realty and Mortgage Referral, LLC, from any loss, liability, damage, or costs they may incur due to any and all wire transfer or directions related to the transfer or issuance of funds, whether cash, check, or wire, caused by negligence or fraud. It is imperative that you use that disclosure. Now, with both of the disclosures, just for reference, whether it's the wire fraud or the buyer-seller, you must get them signed when you're writing the purchase contract. So I'm going to say it again. You must get them signed when you're writing the purchase contract, which means you cannot do it 3 days after. You can't do it at closing. You can't do it a week after. As you hand somebody the purchase contract and the buyer sign it, or as the seller is signing it, they have to sign the wire fraud disclosure as well. You can't do it after the fact. On Facebook, there is a video that is being circulated all over Florida. It's actually a firm called Luxury Beach Realty. And what's most interesting about it is there is a reporter that is literally knocking on the door of Luxury Beach Realty's office, and they're trying to find the real estate agent and the broker because one of the buyers that was working with that firm literally got swindled out of $10,000. Now, I also want to talk about one more disclosure we have, which is the buyer and seller disclosure. This particular disclosure is 3 pages. I'm not going to go over the entire addendum. What I will do is I do want to go over simply one small paragraph, which is paragraph 11. Timeframes, deadlines, and terms. Buyer and seller acknowledge that purchase and sale contract and addendums have timeframes, deadlines, terms, and specific time-sensitive requirements. Buyer and seller acknowledge under no circumstance shall the broker, agent, realtor, or real estate firm be considered in any way responsible for the legal determination or interpretation of such timeframes, deadlines, terms, or specific time-sensitive requirements. Buyer and seller acknowledge that they take sole responsibility for the understanding and implementation of such timeframes, deadlines, terms, and specific time-sensitive requirements, as well as acknowledge that Florida Home Realty and Mortgage, LLC, Florida Homes Realty and Mortgage Referral, LLC, broker, agent, realtor, and real estate firm recommends that the buyer and seller seek attorney legal counsel related to any and all timeframes, deadlines, terms, and specific time-sensitive requirements related to the contract and or purchase and or lease of property. Seller and buyer also indemnify and hold harmless the broker, agent, realtor, and real estate firm related to the legal interpretation of timeframes, deadlines, terms, and specific time-sensitive requirements, and acknowledge that in no way can the broker, agent, realtor, or real estate firm make legal determination on the legality of the aspect of the contract. Indemnification and hold harmless includes, but is not limited to, all aspects of binder deposit, financing, financing contingency, title, close date and extensions, lien search, property condition, taxes, buyer closing costs and prepaid, seller closing costs and concessions, lease terms, binder dispute, maintenance of property, inspection of property, repair of property, utilities of property, personal property of seller and buyer, and determination of the legality of what constitutes acceptance of contract or the legality of what constitutes cancellation of contract. This is a mandatory required document. There are signatures for both buyer and seller. This, like the wire fraud disclosure, must be done while you're actually writing the purchase contract. You can't do this after the fact. You don't use this document or the wire fraud addendum when you're actually writing the listing contract. These two are not necessary. You will use these two documents when you are either on the listing side or the buyer side, either or, when you're actually physically doing the purchase contract. Like the wire fraud disclosure, you cannot do this after the fact. You cannot say, I will have this signed at closing. You can't have the purchase contract signed, and then after the fact, the next day or next week or next few days later, try and have buyer and seller do this addendum. It must be done at the same time. Think of it this way. And one of the reasons why this is so important, because it needs to set the stage and the expectations to a seller and a buyer of what your role is and what it is not. Think of that you have a court of law or a judge. That's one party. Then you have an attorney. Then you have a realtor. The court of law makes a decision. They have the absolute legal ability to figure out what is binding and what's not binding. That's their right. Where an attorney, they can form a legal opinion or give a legal opinion. That is their right. A real estate agent can do neither. And this is the most important part. A real estate agent does not have the right to give a legal opinion. They do not have the right to give a legal interpretation. And they absolutely do not have the right to decide what a court may or what a judge may or may not decide. And this is in all respects. Consider the last paragraph for a moment, the actual last paragraph that I said in the last part, where it said, the real estate agent is indemnified from determination of the legality of what constitutes acceptance of a contract or the legality of what constitutes cancellation of a contract. If a buyer or a seller, take a seller for a second, if the seller basically said, we received an email from an agent, and the other agent who has the buyer stated that our buyer is having difficulty. We're pretty sure we won't be able to move forward. We're going to have to entertain possibly canceling. Let me know your thoughts. It is not the agent's job on our side to determine, is that legal or is it not legal? The only person that can decide what is legal is actually a judge, and the only person that can interpret for a buyer or a seller in any possible way what the contract means or what an offer means or when something's actually canceled or not canceled or accepted or not accepted is actually a judge. So this document takes the real estate agent out of the loop of being the one that actually has to be saying that I'm interpreting this document, I'm interpreting the email, my legal opinion is you'll be fine. You as a real estate agent do not have the ability to give a legal opinion. You cannot tell the buyer or seller when something is actually accepted. You cannot tell them when something's canceled. You cannot form a legal opinion as far as what might be enforceable and what may not be enforceable. You don't have the right to do it. So again, this is a quick message. It's a protecting your practice video. I'll be having a series of this. The two takeaways on this particular one is the wire fraud addendum as well as the FHRM buyer and seller addendum. They are both a required document. If for whatever reason a buyer or seller that you represent will not sign the buyer and seller addendum, you must at the same time send them an email that Florida Homes has drafted, and we will give it to you where it basically states, here's a copy of the buyer and seller addendum. You have elected not to sign it. Here's still the verbiage so you can see this is our policy and that we are not a court of law and we're also not an attorney and we do not have the ability to make determination of fact. You cannot actually interpret. So if you do not have a buyer or seller representing that's willing to sign this, you still must send a company-approved email real time to that buyer or to that seller, basically proving that you gave the addendum. In the actual email itself, you will actually have certain verbiage spelled out so we can prove that they understand this is not your ability. You do not have the ability to accept a contract. You do not have an ability to say if a contract's canceled or on any of the other points. All right, I appreciate everybody's help. We will be providing that email as well. The back agent system will have the FHRM wire fraud disclosure as well as the FHRM buyer and seller disclosure, and it will also have a copy of the email written out for you in back agent. So if they don't want to sign it, you can simply take the body of that verbiage, put it in an email, but you must send that real time. You can't do that 10 days later at closing. That's not, you have to get that email sent in place of those signatures. It also proves to us that you asked them to sign it, because it basically will state that you've elected not to sign, therefore I'm sending the email. If you have any questions, please call me. I'm at 904-412-7889. Thank you so much.